Thank you, Maggie, and hello, everybody. Like Maggie said, I'm an employment litigator, and today I'm going to be taking everybody through the anatomy of a civil lawsuit, basically trying to provide everyone with a bird's eye view of the process of a civil lawsuit. And a civil lawsuit is a lawsuit between a person or company and anyone else to right or wrong. It's different from a criminal lawsuit in that a criminal lawsuit is a claim that's brought by the government because somebody violated a criminal law or criminal statute. This is a civil lawsuit is brought by a person or a company to right or wrong, and and it's sort of like the way I feel about going to the mechanic for the first time. It's how do you know what lawyer to go to or what the process is like, and it's kind of scary, and suing people kind of has a stigma to it. And so today I'm going to try to familiarize you with the process a little bit as best as I can. Now, I'm going to be going through the different stages of a lawsuit, and it's going to track primarily my experience as an employment litigator. But whether you're bringing a claim for unpaid wages, discrimination, or perhaps something else, if you're a company that's suing another company, which is commercial litigation, or if you were injured by a product liability, or if you believe that a doctor performed a medical procedure negligently, that would be medical malpractice. Although the process that we're going through today might be a little bit different, it is typically this process and procedure that we're going to be going through that is going to be the same regardless of the type of lawsuit that you're bringing. And so let's just jump right in. Okay, so I emphasize that this is your lawsuit, and that's such an important thing for you to remember, that it's your lawsuit. It's not the lawyer's lawsuit. It's not the lawsuit of somebody else. It's your lawsuit, and so it's important for you to be aware of the process when it comes to your lawsuit. So, for instance, your lawsuit really starts at that moment when you think somebody's wronged you in some way, and the second that you get that. And the moment that you feel that somebody's wronged you, that's the moment your lawsuit starts. And this here is the process: you finding the right lawyer, the consultation, the retainer, filing your complaint, the discovery process, motion practice, trial, and then post-trial. That's the process from start to finish. Okay. So let's get started. So you think you might have a lawsuit. Here are 3 things that you should keep in mind the moment you think you were wrong. One is to preserve relevant evidence. Most people don't necessarily think about this because preserving relevant evidence might mean that if you have an iPhone and it's automatically deleting messages after a certain amount of time, that you have to stop that. And I highlight that it's relevant evidence, not just good evidence for you, but also perhaps bad evidence for you. That's something that might harm your case. And the reason why you have to preserve it is because, one, you have an obligation under the law to preserve all relevant evidence that might go into your case, but also because there's a presumption down the road. So let's just say you did not act to preserve messages that were sent that could help prove your case or hurt your case, or pictures were deleted for whatever reason. If that occurs, then there's going to be an assumption that you got rid of the evidence because you thought it was so bad, and that's going to be presented to the jury at trial. So-and-so just thought they brought this lawsuit, but they knew they were bringing a lawsuit, but they lost these photos. I think we could all assume that these photos would have been damaging to their case, and so even if those photos would have been good for your case, and you accidentally lost them, it gets spun around and it works against you. So it's so important for you to preserve all evidence the second you think that maybe you might bring a lawsuit, even if you don't end up bringing one. The second is be cautious on social media. The things you say publicly will be found, and you'll be asked about them. And so the second that you think you might have a lawsuit, you have to be aware of what you say publicly and privately to other people, because those, even if you don't necessarily mean what you're saying or it's a joke, those things could be used against you. And you want to put yourself in the best position to help your lawyer win your case to right the wrong that you feel occurred to you. The next step is finding the right lawyer, and this is very, very important. The first question that you have to ask yourself is, what type of lawyer do I need? And to do that is not necessarily so easy. Even in the employment context, something might have happened to you at work, but that doesn't mean that just because I'm an employment lawyer doesn't mean I can handle all employment law claims. I don't do workers' compensation. And so if you have a workers' compensation related issue, if you called me up, I would refer you to somewhere else. So the first step is to figure out what kind of claim that you have, and you could do that usually by going on the internet and doing some research and typing in, this happened to me, what kind of lawyer do I need? Once you figured out the type of lawyer that you need, then the next step is to contact that lawyer, and the way that you can do that is, the best way is really through a referral. The referral could come in one of two ways. Either a lawyer if you know a lawyer, or if you contact a lawyer, and that lawyer says, I don't really do this area of law, you can you'll ask that lawyer, okay, well, can you recommend somebody? A lawyer is probably in the best position to refer another lawyer because they sort of understand the industry to an extent. My clients will ask me all the time if they say they get hurt. I don't do personal injury, and if someone gets hurt, they'll say, okay, well, a personal injury lawyer? And I say, yeah, well, where did you get injured? Was it upstate New York? Was it in New York City? And I might refer them to lawyers who I happen to know are competent at their job, and I'd refer them to those personal injury lawyers, and my clients can feel confident that they are they have quality representation. Obviously, not everybody has access to a lawyer to ask for this, and so you may ask one of your friends who had a similar issue. You don't need to be referred to a lawyer by another lawyer. You could also be referred by a friend. A friend might have had a similar issue, and they may say, well, I use so-and-so. If you have a friend that has an employment issue, they may say, well, I use Jack Newhouse, and he was good, and this is what I liked about him, this is what maybe I didn't like about him, and you could call me up at that point. The backup is using the internet. If you're going to search for a lawyer on the internet, one of the most important things that you should look out for is you want to contact a firm that does what you need it to do. I'm not saying that there might be firms that handle personal injury and employment law and all these other different areas, and that's fine. I'm sure that they might be good, but you have a better chance of getting quality representation if you contact a firm that focuses on the particular area of law that you need. And so that's what you want to look for if you are searching the internet for a firm without having any sort of referral source. Once you contact that lawyer, the lawyer is going to say, okay, it's time for a consultation. It might be over the phone, it might be in person. Of course, with COVID-19, things are a little bit different. Usually they're a bit more usually remote now. The consultation process, that's whenever you are reaching out to a lawyer for legal advice, that conversation that you have is privileged and confidential. That means that there is something called the attorney-client privilege. You can tell that lawyer anything you want, and that lawyer is not allowed to speak about it to anybody. It is completely confidential. However, if you happen to tell a lawyer that you intend to commit a crime or somebody to hurt somebody in some way, that lawyer doesn't have an obligation to keep that quiet. They're allowed to go tell the authorities. But other than confessing a future crime that you intend to commit, everything that you tell a lawyer is completely privileged and confidential. So it's very important that and the purpose of that is so that you're open with the lawyer so that the lawyer can best represent you. So a couple of tips for maximizing this consultation. The first is ask ahead of time, make sure it's free. Most consultations are free in my industry. If you're an employee looking for employment legal help. In the personal injury context, I think it's also typically free, but it's not always, and so you should ask ahead of time, because the last thing that you want is a $500 bill at the end of what you think is an hour-and-a-half conversation with a lawyer where you didn't even hire them. So you may want to ask ahead of time. The second is to make the most of your consultation, try to remember as many facts as possible and communicate them as clearly as you can to the lawyer, because the lawyer is evaluating your case, and you want the lawyer to, first off, see you as a good witness in the future, but also to really understand your case. If you can't communicate your case to the lawyer, then the lawyer won't understand it, and the lawyer won't be able to represent you as best as that lawyer can. And so preparing ahead of time is a great thing. And you could even write down you could write down what happened to you and the chronology of events, the dates, the times, the names of witnesses, and different things like that. And that will help the lawyer very much, and it'll speed up the consultation process as well, which will save you time in the end. The other thing is preparing and bringing all relevant documents. Whatever you think is relevant to the case, bring it. Your lawyer's job is to hold on to these records until trial and when they need to be used, and to preserve them. If your lawyer is preserving them, then that will shield you from if you have a fire in your home, if you lose them for whatever reason, you move. I mean, I can't tell you how many times my clients, they move during the course of a lawsuit and they've lost their calendar where they've recorded the hours that they've worked, and now you have this awkward issue where, oh, well, maybe they lost it on purpose because it's bad for their case. So bring all your documents, give it to the lawyer will hold on to it, they'll preserve it in a way that it needs to be preserved in order to best represent you when it comes time to provide that information during the discovery process, which I'll address later, and at trial. Ask questions. Remember, it's your lawsuit, so ask a lot of questions. Can you explain the law to me? What are my rights? What are the next steps? What are my commitments during this lawsuit? What's time commitment? What are you going to need from me? How often am I going to hear from you? How long will the lawsuit take? Are there fees and costs? And I hope that the lawyer explains that to you, and I'm going to go through that in a moment as well. And what is the statute of limitations on my claim? And if you don't know what a statute of limitations is, it is so important. The statute of limitations is the time period that you have to bring a lawsuit. So under the New York wage law statutes, the laws give you 6 years to bring a lawsuit. So if you claim unpaid wages against your employer, you have 6 years to bring that case. Under federal law, it's 2 years or 3 years, depending on the type of case. And so it's so important to know that, because you have to file your lawsuit before the limitation period is up. So let's just say you decide that you don't want to use that law firm or that attorney. You want to know what your statute of limitations is, because you want to make sure that you don't miss it. You may decide that you're going to go with a worse lawyer who could start the case as quickly as possible if you're right up against that deadline. Let's just say the consultation goes great, and so now now you are going to enter into a relationship with that lawyer, and so that relationship is memorialized in something called the retainer agreement. The retainer agreement primarily refers to the agreement between an attorney and a client, and it'll identify the primary terms and conditions of that relationship. But the retainer can also refer to something else, and it's important that you know this, and it really depends on the type of lawyer that you're hiring. So if you're hiring an employment litigator and you're an employee, the retainer refers to just the agreement. We don't charge an upfront fee, but the retainer could also refer to an upfront fee. So law firms that charge on an hourly basis might ask for a $20,000 retainer upfront, and that money goes into something called an escrow account. Escrow accounts are very closely monitored, and law firms have to take them very seriously, because they're holding on to client money. And the money goes into this escrow account, and from the escrow account, the firm bills a certain amount, and they're allowed to take their fees from the escrow account directly until it goes down, and of course, the client will get a bill for the exact amount of fees and the amount that's in the escrow account, the amount that's in the escrow account, the amount that was taken out of the escrow account. Let's just say during the course of the case, the lawyers only spent $15,000, but there's still $5,000 left over. That money gets returned to the client. It's not like the lawyer gets to keep it. The retainer agreement has to explain fees and costs. And when it comes to fees and costs, I make sure to explain to all my clients that there's a difference, and they are different. The fees are different than costs. And so there are really three different ways to charge fees. The first is the contingency fee, and that's the way that my firm typically bills, and that is a percentage of recovery. So if you win $10,000 and the typical contingency fee is 1/3, then you have to pay $3,333 and in fees to the law firm. The other is hourly, and if you are being charged on an hourly basis, then the law firm has to provide you with their billing rates. So associates bill at $200 an hour, partners bill at $500 an hour, whatever it is. Or you can agree on a flat rate or anything in between. It could be partial contingency, partial hourly, but either way, this has to be memorialized in the retainer agreement. The next are costs. There are a lot of costs in a lawsuit. Initially, there is a filing fee to just start the lawsuit. But there are also lots of fees throughout the case: printing fees, legal research fees, fees for a deposition transcript. The deposition is where you get to ask a witness under oath questions, and though the answers and the questions are typed out by a court reporter, and that transcript and the court reporter cost money, and so these are costs that are sometimes they're fronted by the law firm and have to get paid back either immediately or at the end of the case, whatever your agreement is with the firm. They have to get paid back by the client. And the lawyers in New York are obligated to provide a statement of client rights, and these are it's honestly it's common sense. You have to be lawyers have to treat their clients with respect and courtesy. Attorneys have to be competent. They can only charge reasonable fees. I think that there is when it comes to contingency fees, you're not really supposed to be charged more than 40%. I think there are firms that do that. The standard is 33%. You're entitled to an explanation of fees and costs, an itemized bill, if you have any questions, they have to be answered promptly. You have a right to privacy, that's really referring to the attorney-client privilege. And clients must be informed of what's going on in their lawsuit with some sort of frequency. Okay, so once you've memorialized your relationship and you provided all the information to your lawyer, then it's time to start the lawsuit. When you're starting a lawsuit, the first thing is, where are you filing this lawsuit? And so we'll start with state and federal court. This is your typical civil lawsuit filed in court. It can be filed in a state court or a federal court, and that depends on the nature of your claims or who you're suing. If you're suing somebody that is in a different state from you, it could be filed in federal court. You typically bring the lawsuit in a location either where the incident occurred. So if you get into a car accident, it might be where the car accident occurred, or where the parties live. So if you live in New York and whoever you're suing is in New York, you bring the lawsuit in New York. There are other types of lawsuits as well. And when you file a case in state or federal court, it's public. It's a public filing, and anybody could find it. So whatever you put out there could be seen. You could also file claims with a government agency. So for instance, if you have a discrimination lawsuit and you under federal law, you're not allowed to just bring that case in federal court. You first have to go through an administrative agency called the Equal Employment Opportunity Commission. And only through going through that government agency are you able to then bring a case in court. So there's an administrative process also, and that's really not so public. You might be able to get that information, but it's not something that you can find easily on the internet. And the last is arbitration, which is private. It's like hiring a private judge. The only way you can end up in arbitration is if both parties agree to arbitrate. And you start a lawsuit by, and I'm going to focus on the lawsuits in court. I'm not really going to focus on administrative lawsuits filed with the government agencies or arbitration. So to start a case in state or federal court, you have to file something called the complaint. It could also be called the petition or charge, depending on the forum. But you have an initial filing of the complaint and then service. Service refers to the process of informing the person you're suing, which of course is necessary. The complaint. The complaint is filed by the plaintiff, and the plaintiff refers to the person that's bringing the lawsuit. And it has to be filed before, like I said before, the statute of limitations expires. Otherwise, you are not allowed to bring your claim at all. It is the plaintiff who chooses where the lawsuit will be filed, because you may have choices. You might be able to file it in New York County or up in Onondaga County or Suffolk County, depends where. You might be able to file it in upstate New York in federal court or in Manhattan in federal court. And the complaint, and this is the important part, contains the facts that, if proven, will establish your claim. And so, by way of example, if you are claiming overtime, unpaid overtime, you would have to allege that you worked a schedule that required you to work more than 40 hours in a week, and that when you did that, you were not paid 1.5 times your regular rate of pay. And it's those facts that would, that if proven, would establish your claim. So, very important is that it's your lawsuit. So you get to review the facts in your complaint. You should be aware of what you're putting out into the public. Read it. If you don't understand it, ask questions. Especially because you're going to be asked about it later during your deposition, when their lawyer gets to ask questions to you. Generally, these are the phases of a lawsuit. You file the complaint, then there's a response, and then there's the discovery process. In between discovery and trial, there are certain things that occur, summary judgment, pretrial submissions, things like that, and then you have trial. The timeline, I do not hold any lawyer to this timeline, but based on the minimum deadlines, in federal court, you're looking at 6 months to a year. In my opinion, it would not be unusual for lawsuits to take upwards of 2-3 years in federal court, all lawsuits. In state court, you're looking at least a year or two, and that is if all the deadlines are met. Right now, there is like a 2-year backlog on trials. So if you are ready to go to on a jury trial, if you're ready to go to trial today, you may have to wait 1.5 to 2 years just to get into the courtroom, even if you've done everything else in your case. So even though you want to bring your lawsuit, you have to keep in mind that justice is not so quick sometimes. So after you file your complaint and there's a response, there's something called the discovery process, and this is the process. This is the investigation process, and this is the process that really takes the longest during the lawsuit, because this is where you gather your evidence to prove your case at trial. There's 3 main discovery tools, and the first is requests for information and documents. If you're suing for unpaid wages, you're going to ask for payroll records and time records. If it's a medical malpractice, you're going to ask for the doctor's notes and things like that. There's also a deposition where you get to interview witnesses under oath. And last but not least is the expert witnesses. In some cases there are experts, in other cases there aren't. And an expert witnesses can get quite expensive, and you need an expert witness in order to establish something that a regular layman wouldn't know. For instance, a technical process. You would need, in a medical malpractice case, you probably would need an expert doctor to discuss what the normal procedure is in a particular for a particular medical procedure. There are so many disagreements that occur during discovery because, as you might imagine, people who are being sued don't really want to turn over the smoking gun. And so this leads to motion practice. And a motion refers to a request that the court do something, take an action. So in a wage case, if the employer doesn't want to provide payroll records or time records, then we would make a motion to compel the employer to provide us with those records, and the judge would decide whether, based on various factors, whether the employer has to provide those records to us. It is discovery that can get very expensive. So if there's an opportunity to settle before discovery, those are things that your lawyer should explain to you. At the end of discovery, you make a request to be put on the trial calendar, and then you get to the trial. At trial is where you get to use the evidence that you've gathered during discovery to prove your case. A trial could be a jury trial or a non-jury trial, and that's just a litigation strategy. Sometimes you want a jury to make the decision, and sometimes you want a judge to make the decision. There are strict rules about what can be presented to a jury, and this goes back to preservation of evidence. And because it's important that you preserve the evidence properly, because if you don't preserve it properly and perhaps it was modified along the way, then those rules might prevent you from presenting key evidence to the jury, evidence that you need to establish your claim. The jury, and it is the jury or the judge, if there is no jury, that determines the liability and damages. Just because you win a case at trial does not mean that you get what you sued for, unfortunately. There is the appeal process. I have a case we won at trial in August of 2019, and they appealed it, and so we are waiting for the appellate court to issue a decision on the appeal. We don't expect that the court will do that until January of 2021. So you can imagine my clients are waiting quite a bit of time, even though they've already won at trial. They have to wait until January 2021 to find out if the judgment is going to be upheld. And then there's judgment enforcement. Let's just say you win a case against the company that can't pay, or they just decide not to pay, then there's a whole procedure for enforcing your judgment. Okay, oh, actually, sorry, last thing on this. The vast majority of cases settle. So as depressing as some of the things that I've brought up here may seem, the vast majority of cases do not go to trial. I would say about 90% of my cases settle. I think that's pretty standard for 90+% of cases to settle pre-trial. Obviously, that number might change depending on the type of area of lawsuit that you are going to bring. Okay, and so in sum, this is how to maintain your realistic expectations and to really help yourself during a lawsuit. First, come prepared at the consultation. Present the case to your lawyer as clearly as you possibly can. Hire a competent, diligent lawyer. As best as you can, try to look your lawyer up on the internet and ask around, see if you can get a referral to a competent lawyer who does the type of area of law that you want. Check in periodically. I can't stress enough. The amount of time that commitment of a person who's suing is actually not that much, but it could be a lot at certain times. When you have to respond to certain questions, you have to prepare for your deposition. It might be a full week of preparation or a few days of preparation. It might be burdensome to look for all these documents and records that are requested from you. But in a case that might take 3 years, you're really only doing this over a couple of months total. And so most of the time you're not doing anything. And one way to make sure your lawyer stays on top of things is to check in with your lawyer. And so, check in periodically. Ask your lawyer after you check in, when's the next time I should check in? And the judge and opposing counsel are the two main issues that will slow a case down or speed it up. If the judge decides that if you have a discovery dispute and the judge decides that it's going to take 6 months to resolve that dispute, then that 6 months that's lost where nothing can happen. Some judges might take a week to settle the same dispute. And so the judge has a large impact on how long a case will take. And it's random how judges are assigned, so there's no way to know ahead of time which judge you'll be assigned to. Opposing counsel. Some opposing counsel are, some of them are open to settlement and some are not. And very often clients rely on their counsel, and it's usually the counsel's advice that dictates how fast or how aggressively a case is prosecuted or defended. And the last two things that impact settlement is your willingness to settle. That impact how long a case will take is your willingness to settle. If you want to get 100% of everything that you are owed, then almost certainly your case will go to trial. But if you understand that you are willing to take 80%, 70%, 60% of whatever it is you think you're owed, because it might be risky to go to trial, or perhaps because you don't want to spend the next 3 years litigating this case. Maybe it's very emotional. And that happens a lot in sexual harassment cases where someone doesn't want to be questioned for the next 3 years of their life on these occurrences that were actually quite traumatic. And so people might settle for less than they're owed. But if you want 100% of what you're owed, then you're almost certainly going to be going to trial, and the same thing for the defendant's willingness to settle. So I hope that this has been enlightening, and I'm here. I'm happy to answer any questions that you have. And if you want to ask me questions privately, my contact information is on the screen, and feel free to email me or call me. And again, it's completely privileged and confidential, like I mentioned earlier in the conversation. Okay, thank you so much.
Thanks, Jack. That was great. I'll remind everyone, if you have a question now, you can use the chat box, or you can also email info@savvyladies.org. And as Jack said, if you have a question for him, you can reach out as well. And Jack, the first question that we have is asking for your thoughts on how to decide if you should work with a lawyer who has a good record and reputation, but might not be a good fit for you personality-wise.
I think that if your personal relationship with the lawyer is probably less important to, it depends what you want to get. You might be more aggravated working with a lawyer who doesn't gel with you personally. But if you are interested in having a lawyer who can represent you, that will do a very good job, and that will get you the most that you could possibly get by the end of the case, then your personal relationship matters a lot less. And so even though there might be some aggravation, if you're able to live with that aggravation, you'll be better off in the end going with a lawyer who has a good reputation and is competent and good at their job.
Okay, thank you. Another question for you is asking if a lawsuit is settled, how does that affect the fees and the timing? Okay,
so in terms of the fees, you have your relationship with your lawyer, whatever that fee relationship is. So when you are settling and you are discussing settlement with your lawyer, it's so important, bring up fees before you sign the agreement. How do fees work? If I sign this agreement, am I going to have to pay over 100% of the money that I'm receiving in fees? Make sure that you understand fully what you're getting in your pocket at the end. And that's the way to really protect yourself against it. If it's contingency, typically what happens is in a settlement agreement, if you're settling for a certain amount of money, the contingency percentage will be allocated in the settlement agreement itself to the lawyer, and a percentage will be allocated to you, the client. And that's how fees are typically paid out. And I'm not sure what you mean by the timeline. I'm sorry.
I'm going to guess and say it means, does it shorten or lengthen the timing, or is this just settling at the very end? That's my guess.
Okay, you could settle at any time. Obviously, if you sometimes I mean, this rarely occurs, but you filed a complaint, you served on the opposing on whoever you're suing, and then that person will reach out and say, oh no, I don't want to deal with this lawsuit. Here's X amount of money to settle the case. Obviously, that will shorten the case substantially, and you should take that into account when accepting when evaluating the value of the deal that's being offered. But settlements can occur literally at any time in the process. I've settled numerous times on the night before trial, after the first day of trial, after we receive a judgment at trial. And the only difference between settling earlier and later is evaluating the value of the case at that point. You know, you might, once you've won at trial, you're less likely to reduce the settlement amount that you are willing to accept.
Okay, thank you. This next question says, if the settlement is greater than the cost of my insurance, am I responsible for the remainder?
I am, I typically, like I said earlier, I typically represent employees in the process, and so I'm not sure what the answer is to your question, and I'm not sure which side I'm not sure the answer. I would think that you're entitled to the remainder, but it might matter on what the deal is that you have with the insurance company. But I really don't know the answer, so I don't want to give advice, because in my field, we don't typically deal with insurance. Employees are typically not insured in that way.
Okay. A question for you is asking if you know of free resources or other resources that might be available for those who can't afford to hire an attorney. Do those exist?
Excellent question. Okay, so it depends on the area of, so let's just say you can't afford an attorney, you could always reach out to New York. There are different organizations in New York, so like NILAG, New York Legal Assistance Group, or Legal Aid, and they have different areas that they assist with. They do help with employment issues. They also assist with housing-related issues. But one thing to note, especially in the field of employment law, is that there is fee shifting in my field, which means that if you win your case, that the whoever you're suing is required to pay for your fee. So it depends on the area. And so what I would suggest is if you're able to get a free consultation with a lawyer, you should do that. You could definitely reach out to one of these services, again, New York Legal Assistance Group, or Legal Aid would be another one. But reaching out to a lawyer, if you have a free consultation, that you can ask them the question, and it could be that you don't have to pay anything at all to that lawyer in order to bring the case.
Okay, great. And we can include those resources in our follow-up email so everyone has those as well. And Jack, I think this is the last question for you. It's asking, what are some good questions to ask an attorney during an initial meeting, and are there any red flags to look out for during this initial meeting?
Good question. So I'm going to go back really quickly to just so that it's up on the screen. But there are some, and we could send this around if you want, Maggie. I'm happy to do that. But some questions, you want to make sure that you understand your case. So some questions that you might ask is, can you explain the law to me that's relevant to your case, or what your rights are, or what the next steps are? And if the lawyer is having a hard time explaining that to you, then that would be a red flag, because you want your lawyer to very clearly understand the law that is relevant to your case, and what your rights are, and what the next steps are, and what the fees are, and the costs are. Or you can ask how long a lawsuit will take, but I assure you, it's really, really hard to know the answer to that question. So that would not be a red flag. But what your commitments are, if the lawyer is unable to answer it clearly, then that would be a red flag.
Okay, great. And yes, we can include those questions in our follow-up email as well, so everyone has access to that. And we will be sending Jack's contact information as well. And Jack, I want to thank you for presenting today and very clearly explaining what can be kind of a scary process for people, especially if they have not done this before. So thank you for taking the time to explain it and answer our questions as well. And I want to thank everyone for joining us today. And thank you so much, Jack.
Thank you. My pleasure.
All right. Thanks. Bye-bye, everybody.